Good afternoon and welcome to the first Turnaround Talk Roundtable. Before we continue, let's please take note of the house rules. All participants, with the exception of the panelists and the moderator, are kindly requested to mute their microphones and to switch off their cameras. Please make use of the chat function to ask your panelists questions, and I will be presenting them to the panelists at the end of the presentations. Panelists, please stick to your allotted time when giving your presentation. So as we know, business rescue plays an important role in the economy. However, the industry is not without its challenges. Joining me to discuss these challenges are four very respected industry professionals. Gideon Snabbert is a business rescue practitioner at Turnaround Rescue Solutions and holds the title of Junior Business Rescue Practitioner. He will be discussing the success rates of business rescue. Over to you, Gideon.
Thank you, Jonathan. Thank you, viewers and fellow panel members. I've prepared a short presentation for a review that we will be working through. Yes, Jonathan, as you mentioned, throughout my consultation, I have realized that I picked up companies evaluating business rescue, or whether they should go into business rescue or not, always refer to the fact that business rescue has got a low success rate. And even if you look at what is reported in the press, we find that the press and the media reports are 8 to 10% success rate. And then we are, as practitioner or business rescue practitioner, I'm always posed with the question, but what is the chances of success? A very bad figures reported in the field. And this makes me very passionate about this topic, in the sense that active practitioners and companies that have gone through the process of business rescue can report, that there are numerous other factors that needs to be taken into consideration when looking at the success rate of business rescue, and it purely cannot just be substantial implementation. So in my slide, I have prepared what is the true success rate of business rescue. And if we have a look here, this is the most recent figures that I could find according to the CIPC, where they have posted the statistics in October 2020 of the statuses of business rescue in South Africa. I've just highlighted, this is from the beginning of the Act, and I've just highlighted where we are now, 2021. Where for the specific year, 92.7% of the cases are active, 0.86% are in liquidation, and then we go on to nullity, set aside, and substantial implementation and termination. I've taken this graph or this data and just posed it on a graph where we can see the various statuses of the business rescue over time. In my discussion consultation with my peer or fellow business rescue practitioners, what was interesting is, and this is in my view and opinion, is that one can assume, or one could see, that there's a trend in the beginning of 2011 through to the 2014, 2015 year, where it would seem, where most of those cases have been concluded, that the average substantial implementation rate is in the region of 25%. The newer cases, I've in my comparison just looked at the last 4 years of the statistics as published by CIPC. The active cases are still very high, but if one were to make or to be of opinion that at least 20% of the active cases would move over to substantial implementation and most likely liquidation, then it would seem that the success rate still remains in the region between 25 and 30%. In the next slide, I've just made an assumption here where you can see between 2011 and 2014, substantial implementation was in the average region of 23.73%. And in the last 4 years, or the most recent years, it would seem it's going to be in the region of 29%. So what's interesting is that although there is an increase in the success rate, it is encouraging. I've included, although due to time constraints, we can't discuss the full content of Section 7 of the Companies Act, but I encourage panel members and guests on this platform to go and read what is the purposes of the Companies Act. I think all of it is relevant, and more specifically, I've highlighted 7K, which is a clause that we always include in our business rescue plan, and that is to provide efficient rescue and recovery of financially distressed companies in a manner that balances the rights and interests of all relevant stakeholders. What I want to get to, more importantly, the topics not noted and what we as practitioners are faced continuously is, regardless of Section 7K of the Companies Act, the true success of a business rescue is also the economic contribution that a company makes when they actually implement a business rescue plan, in the sense that your supply chain, there's further procurement that takes place in your supply chain. There's continuing SARS payments and contributions made to the economy, workmen's compensation and pension funds. In some instances, not all, there's continuations of employment in full or alternatively on a reduced basis. We see now in our critical industries, there's most of the times preservation of specialized skills within various industries. And then, as defined in the Act, successful business rescue can also mean that a better return than in liquidation is offered to affected parties in terms of dividends. And one of my favorites is business rescue could also preserve special licenses, such as a mining right, as opposed to liquidation. So I actually encourage industry members and business rescue practitioners to also place focus on the factors that we don't always see in the Act, or report on these factors as opposed to only reporting on substantial implementation as such. Thank you.
Thank you. Thank you very much, Gideon, and thank you for the very interesting presentation. If you could just end your screen sharing. Let's move over to George Nell, who is the CEO of Corporate Business Rescue. He holds the title of Senior Business Rescue Practitioner, and he will be discussing fees. Before we move on to George, just a reminder that the copy of this roundtable will be made available on Turnaround Talk, on the Turnaround Talk website at a future date for those who have not been able to make it, or those who have not been able to go through the whole roundtable due to technical issues. George, over to you.
Thank you, Jonathan. Thank you for the opportunity at Turnaround Talk Roundtable, and I hope that I can contribute something this afternoon. In regard to the fees of a practitioner, all know that the Act was enacted on the 1st of May 2011, and Regulation 128 spells out the tariffs that may be used. Now, these tariffs are 10 years old and is not a proper tariffs in any case, but we as practitioners can get a better tariff if we follow the following route. This is not legal advice, this is only my own opinion, so please follow the route if your lawyer also advise you to do so. So the tariff for small companies, 1,250 Rand an hour and 15,625 Rand per day, VAT inclusive, and that is a company that's sub 100 public interest score. For a company that is a medium company, the tariff is 1,500 Rand an hour and 18,750 Rand inclusive of VAT. So just the inclusive of VAT, in the meantime, since the enactment of this Act, the VAT went up from 14 to 15%. So business rescue practitioners was then also hit by 1% reduction in fees at that specific time. And then a large company, 2,000 Rand per hour and or 25,000 Rand per day. And it's roughly, they worked it out on 12 hours a day. So my suggestion to you is to enter into a written agreement. Section 150 of the Act subsection, let me quickly have a look there, subsection 2A Roman 5, say that the copy of the written agreement concerning the practitioner's remuneration should be published with the business rescue plan. And if we look at section 143, which gives you the rights and gives you the right to charge fees, there's a subsection 3 of that act, the part that is in red, present and voting at a meeting called for the purpose of considering the proposed agreement. Now, this agreement is used for further remuneration. So my proposal is that you add your further fees on top of your hourly tariff. For instance, if you work at 3,500 Rand an hour, that will be 1,000, and that is a senior matter, a large company, that will be 1,500 Rand on top of the 2,000 Rand. You must just make sure that that is deemed further remuneration. You should have called a meeting in terms of section 143 sub 3 B to call for a proposed of the consideration of the proposed agreement, and then enter into that agreement by a vote by the creditors and by the shareholders of the company. If we look at section 143, just on the top there, just go down, please. Go back to the agenda, the first part of the thing. Thank you. Just stop there. So this is the wording that the legislator chose is final and binding on the company if it is so approved. So it seems if you can enter into the agreement prior to the ratification of it by the creditors and by the shareholders. So you enter into the agreement, take some fees on top, arrange with and agree with the company that you work at a higher rate than the 2,000 Rand an hour in the case of a large company, and then put that to a vote at the meeting in terms of section 151, where you determine the future of the company. Have a separate clause in your business rescue plan, call it section 143 sub 3 A and B meeting, and have a vote on that. And once you have that vote, it is binding on the company. Thank you for the opportunity to share this with you.
Thank you very much, George. If you could just disenable your screen sharing so that we can move on. Thank you very much. Please make use, members or participants joining us, please make use of the chat function to ask any questions to our panelists. I will be presenting them at the end of the presentations. Let's move on and shift gears to Charles Peary, who is an associate at Untitled Business Consulting. Like George Noel, Charles is a senior business rescue practitioner. He will be discussing the issue of lack of legal clarity and no specialized courts. Charles, over to you.
Thank you, Jonathan. Let me just clarify. I'm experienced, not a senior. Can you hear me, guys?
Yes, apologies. I'm actually moving you up in the business rescue world, so you should be thanking me.
You're moving me too fast. Okay, no, thank you a lot, Jonathan. I would like to thank my fellow panelists for this very interesting panel that we have today. It's quite an honor to be with you, the likes of Robin and the likes of George. I know you guys, you have done a lot into this industry. So as the presenter said, the current challenges that I'm interested to discuss with you guys or to share with you is when it comes to the decisions that are being made by our courts. I find it very interesting that most of these decisions that are being made, they are not aligned to what the drafters of the Chapter 6 of the Companies Act aimed to. If you look at the decision that was made in the SA versus NUMSA on the Labor Court, you will notice that what the union argued, they argued about Section 136(1)(b). What they said was that in their understanding, they kind of saying that the section only empowers the business risk practitioners to commence the retrenchments or as soon as the business risk plan has been published or has been made present or published. But if you look at the wording of Section 136 itself, that's what it doesn't say that. Section 136(1)(2), it says that the business risk practitioner may suspend or cancel employment unless employee agrees. So look, sometimes we go into, we take an appointment to be the business risk practitioners, and you find that the very same week, some of the employees are coming to you to ask for retrenchments, VSP. But then now, what the judgment says is that if you entertain that, that will be constitutional unfair. But that's not true, because the wording of Section 136(1)(b), it simply says that you as the director of the company now, after being appointed, you have to make the decision whenever you are implementing the plan, whenever you are publishing the business risk plan, it has to be in line with what you feel the company or the organization will be risked. And if you notice that, you might notice that most of the companies, they've got a lot of employees, and during the business risk, you really need to do some retrenchment so that you can save a lot of cost and move on publishing your plan or maybe implementing the plan itself. But then this court decision, it made a lot of us BRPs that the moment that we walk into an organization, we can't practice any retrenchments up until the plan is adopted. This, from my understanding, it's a big challenge. It's a big challenge because it's limiting the business risk practitioner on the powers that you have. And I believe that if we can take further this for an appeal, maybe at the Constitutional Court, we might likely this might likely just wrong when it comes to law. And now the other part of another judgment that I can't find it to be very interesting and also not in agreeing with is the Mango judgment. If you look at the Mango judgment, what the shareholders of Mango said was that we adopted the plan to file the business rescue for Mango on 16th April 2021. But then what happened, they did not file it at the CIPC. But Section 129(3), it says that it has to be filed within 5 days. Once the resolution has been reached, it has to be filed for the resolution to be effective, or for the company to be considered that is in business rescue. It has to be filed within 5 days. But then when it comes to the Mango Airlines, they reached a resolution, but they just kept the resolution in a briefcase. They could not file it. And then 3 months later, they approached CIPC to say, no, Mango is in business rescue because we reached the resolution sometime in April, but it was not filed. It was not filed to be effective. But then come to Judge Anthony. In his judgment, he said, no, it doesn't matter. The 5 days does not, it doesn't matter whether it's 5 days or it's 3 months, but as long as they reach the resolution, we deem it to be valid, we deem it to be effective. And on his judgment, he declared that no, with effective from 28 July, Mango has to be in business rescue. But then again, you notice the Chapter 6 of the Companies Act is always under attack, each and kind of trying to work as business risk practitioners. And all what I can say, I think, to conclude this, is that our independence is not recognized when it comes to BRP. Thank you very much.
Thank you very much, Charles. Again, a very interesting and important topic. Let's move over finally to Robin Nicholson, who is a director at Corporate 911 and is a senior business rescue practitioner. Robin will be discussing regulatory concerns within the industry. Robin, over to you. Robin?
There we go. You should now have. John, has it come up as a slideshow on your side?
Yeah, it has come up. Yeah, now it's a slideshow.
Okay. Our friends at CIPC recently issued a practice note 3, and then they disguised it as saying, you know, it was all about electronic filing. But actually it isn't, and that are helpful, and there are a couple of things that are starting to make the world a little bit more difficult for both practitioners and company directors in particular. So it says Part A is the commencement of business rescue proceedings, and it supersedes the notes of 2014 and 2020. It's interesting that the note addresses some of the abuses in filing that CIPC and the industry have noted concern for quite some time. One, the use of
Sorry, Robin. Looks like we have some technical glitches. Please just unmute yourself.
Sorry, Jonathan, where did I go?
I think just start on this file. Just start on this slide again, please.
Sorry about that. So the note addresses some of the abuses in filing that the CIPC and industry had concerns about for some time. The first one is the use of inactive or new directors to lodge the resolutions. And quite simply, did they have sufficient knowledge about the operations to make the determinations that the company is in financial distress and that it has a reasonable prospect of rescue? Also, another loophole is directors signing the notice must be the same director who signs a sworn statement of affairs. And I think we'd go further and say it also signs the minutes of the meeting. That closes this use of a nominee director to place companies in business rescue. So I'm sure all of us have had the experience where the directors themselves won't or don't want to place the company in rescue for whatever reason, and then they appoint a spouse or a friend or someone else to the company to sign all the documentation in the hope that that will help them avoid the consequences of perhaps reckless trading and the like in the past. Interestingly enough, this should sort of help in Helion. They've included the use of the SARS code for the nature of the industry classification, the so-called SIC code 7 that SARS have, which will help the classification of size, industry, and type of companies that are in rescue, if the CIPC is actually capturing that in any meaningful way. The other one is, of course, and George would know a lot about this, given his years of experience in the insolvency industry. This idea that you could, locate the main place of business out in Roos-Senekal or Fourriesmith, and really force the affected parties to travel to those remote areas, thereby reducing this requirement of in-person and present. Of course, Zoom has also changed that quite a lot. But perhaps the biggest one is the changes and clarifications to the requirement on the sworn statement of affairs. The reasons for the resolution to commence business rescue proceedings with a clear indication as to the cause of the financial distress, and quite clearly not having enough cash isn't a cause of the financial distress, it's really a symptom. The requirements for a preliminary plan to address the financial distress. And that's definitely something that is new. In the past, you had to give reasons with little evidence to back it up. But now they've resting on the preliminary plan. one we know about is all legal proceedings the company is involved in, and also state whether the company is not involved in any legal proceedings, which seems to move from this reporting obligation to a positive obligation, in that the company has to report its own proceedings that it may be contemplating or considering. So to my mind, there's clear, there's a case of Yabi Dragons for the unsuspecting directors. So let's just have a quick look at that. Clearly indicate the date of the resolution, the name and registration. Now, we've all seen the case where there are divisions. So the guy incorporates 3 companies and runs it as one set of books for multiple companies, and he puts that company in rescue. But one division's in trouble and the other is solvent. So you've got this unpacking of issues. I think the big opportunity for SIPC to consider in that changes to the Companies Act is a group business rescue as opposed to the individual company rescue. There's a reasonable prospect to rescue the company. The director is identifiable and is the same director's sworn statement of affairs. So that requirement goes to that inclusion of the document. And that the majority of shareholders have resolved to commence the business rescue. I would recommend that, in fact, all the directors sign the resolution to commence rescue. The practice note sets up a clarification for the accountability of directors and indicates the rescue plan may look like. But in reality, how often does that happen? And these statements tend to be quite brief, non-committal. I think courts would go so far as to say vague and embarrassing in law, but they are going to be challenged in the future. It's just a matter of time when the litigation gets big enough or the rescue gets big enough. We already know that there's a lot of debate around directors' liabilities, and we all know that the major banks always ask for the sworn statement of affairs, and they go through it quite carefully. And the business rescue plan itself is required then to answer all of the issues that the directors have set out in their sworn statement of affairs, particularly where you come across false statements. I think it's incumbent on everyone just to recognize that Southern Palace Investments versus Midnight Storm, sorry, Jonathan, about the spelling mistake, is something more than a reasonable probability is required. So directors have to apply their mind to come up with that it's a real possibility. There's a concrete and objectively discernible detail going beyond mere speculation. In a trading company, likely costs of being able to resume conduct of its core business, the likely availability of cash resources to fund the rescue and continuing operations, the availability of other necessary resources, and the reasons why I suggest the proposed rescue plan will have a reasonable prospect of success. So there's quite a consideration that has to go into the sworn statement of affairs, and one would expect that to actually be quite a detailed document. The clarification in those now placed a clearer burden on the directors signing the sworn statement and the directors for the business rescue. They've got to provide a clear high-level business plan for the basis for their reasonable belief that there's a reasonable prospect per the Southern Palace judgment. And the question to me comes, how do they evidence the basis for their reasonable belief? There should be at least a solvency and liquidity test that shows the extent of distress and support the proposed plan. Some form of cash flow forecast that shows the extent of the distress and the time available for a full-blown crisis develops. Consideration of the impact of the business rescue itself. Will clients stay or will they leave? A basis for the selection of the practitioner and reasonable skill in dealing with companies of this nature and this type of industry. And then probably also an independent business review by a skilled person in doing this if the directors don't really want to put the proverbial on the line, the so-called expert opinion. Now, I'm sure if you're just trying to straw poll amongst the people on this panel, Jonathan, you're going to find that very few of them have ever seen this in reality. So the evidence needs to be available if the directors are challenged, but I don't think it's necessary to attach it as sworn statement in terms of the new practice note. So really, the big focus seems to have been on getting to grips with this reasonable prospect in the sworn statement of affairs, and how the directors thought they would save the business. I think the big risk for many people in that process is going to be, what if your rescue plan differs to what the directors thought was reasonably possible to achieve? Okay, there's no significant change other than the electronic submission addresses in parts B to D, which covers commencement by court action, monthly reporting, and notice to cease or desist of business rescue. They have up the requirements to confirmation on the evidence for the basis of the termination of a rescue, the filing for provisional liquidation if that's the route it's gone, or the meetings if the plan is not voted on within a specific time frame, or extensions. And then another small change is the notice of substantial implementation requires a new PR score to be submitted. And I would imagine also that if the SIP code has changed because it's now a dormant company or the like, that should also be submitted. Jonathan, so that's my story. Thank you.
Thank you very much, Robin. If you could just end the screen sharing, that ends our panel, the panel presentation part of the discussion. If anybody's got any questions, please provide them in the chat function. Robin, I do see that you sent a message to Charles saying that the Mango judgment has already been sort of abused. Can you just discuss that in a little bit more detail?
Well, it's one we came across this morning when we were reviewing, and by a bunch of, in a property developer who claims that he commenced business rescue on the 5th of September, but he hasn't yet filed with the affected parties, and he hasn't yet filed who the business rescue practitioner would be. And it's a very high profile case. It's been on carte blanche recently. So, and clearly they're taking advantage of this. Well, they filed, they passed a resolution the 5th of September. They've got some time, according to this judgment, it's like never ending. When the pauper hits the fan, they will then go and file. And I've got to agree, Charles, I think that decision in Mango was shockingly bad. In fact, I would go so far as to say the CRPC and the professional associations should take it on review at a minimum. It is just so bad.
Look, I think if we look at all of the presentations, it all comes back to the fact that there needs to be a little bit more engagement with the regulator and possibly a little bit more tighter regulation. I mean, just going back to Gideon with your presentation on the success of business rescue, obviously we have to have more engagement with the press with regards to the success. But who does that come through? Does that come through individual BRPs? Does it come through member associations like the TMASA and SARIPA, or does it come through the CRPC?
Well, Jonathan, I think just in fairness to the CRPC, they've set up a committee with all of these bodies. But, initially it was going to be 4, maybe 5 bodies, and now you're up to 18 or 19 on the BR liaison committee. So I think it is on the professional associations to use that forum to start motivating these changes to both the legislation and the behavior of CRPC. I mean, we're all very supportive of the CRPC and the difficulties they have around being swamped by the number of new rescue applications and their limited resources of people in town, in the office, and the number of new licenses that they've issued. But they need to do a very careful job about this. There's big risks on the table for directors and for practitioners if they don't get it right.
Yeah. Gideon, you wanted to add something?
Yes, thank you, Jonathan. I believe that it is the job of all practitioners and institutions to actually communicate this figure. Personally, I do not feel that it is being communicated as good as it could be. If you go look, interestingly enough, on Google Trends and you type the word business rescue, you will see also interesting for me. I can't explain it, but if you type the word business rescue, there's only the peak searches for the word business rescue is 100 during, let me say this, from March 2021 to date. And this figure is extremely low. And if you look at who are the companies that are driving the messages of the concept of business rescue, it is the likes of SAA, the SAA Business Rescue and the EdCon Business Rescue. So in my view, I don't believe that practitioners are marketing and doing enough, and also the professional institutions. Thank you.
George, do you agree with this sentiment?
If we look at the success rate of business rescues, I think we as practitioners should do a bit more to market the product. We in our office has a fairly high success rate, not initially. In the initial stages of business rescue 10 years ago, I took on every second matter. Now I think actually took on every matter, and the success rate wasn't very high. So later on, we developed a pre-assessment, which all my colleagues are following. They're not following me, but are doing now. And with a pre-assessment to differentiate between liquidation and a possible business rescue, the success rate has gone up. So if that was the question, that is my answer.
Jonathan, I think George points to an important point to all practitioners, which is once bitten, shy of your fees, you learn to be a lot more selective in which rescues you take on board. In rescue, you can pay real school fees if you take on the wrong client. I think we've all had that experience.
I think one of the things that, and I'm sorry if I'm putting any one of my panelists on the spot here, one of the challenges that we haven't spoken about is COVID and the actual implications that it has had. I know we all sick and tired of talking about COVID, but there was that delay at the CIPC in lodging business rescues because of COVID. There is delays at the courts because of COVID. And, companies who are in business rescue are financially strained at the moment and possibly can't afford the fees that were discussed by George. I know that those fees are guidelines, but at the end of the day, business rescue practitioners are not working for the Salvation Army. So what role has COVID played in the whole business rescue industry as a challenge?
Jonathan, maybe I must it is not guidelines, it's legislation. That is the top fees you may charge. And so that is a misconception that it is guidelines. Secondly, while I've got the floor, in my practice, my debtors book now that is has went up after the dinner judgment. I tried to run a cash business. I send out on a weekly statement, and I want to get paid shortly thereafter. And then it went well for a while. But this year, my debtors book has gone up with 40%, showing that the projects that I've got in my office cannot really pay. So now I get, after a while, I become a creditor, in inverted commas, of my own project. And I think that can influence my objective judgment. So I think that COVID has influenced the situation to the detriment of everybody in the country, work opportunities, lawyers and companies and business rescue practitioners.
Does anybody else want to add to the whole COVID as a role player?
Well, Jonathan, I think that George is right in terms of those companies going into rescue. But the other thing that it's doing is the banks themselves are sitting with a lot of clients with exposures of less than 20 million rand in the workout departments. They, if you try and speak to somebody in the workout department right now, it's impossible to get a hold of them because they are busy trying to work out so many of their clients. And they really don't want their clients to go into rescue for any number of reasons, but most of all that they see it as a further financial drain on the resources of the company that's already strained. So, you know, a lot of what is COVID related has ended up with these investment supporters like the NEF, the IDC, and these various funds, and then in large bank workout departments. You know, it's only really going to be when things return to normal and they have to deal with a headache that the workouts are going to move out of the bank turnaround departments into business rescue. Because we all know one of the principal causes of business rescue is over leverage. You know, if your business can't support the debt, you're going to end up in the trouble, and then you're going to look for a haircut. You know, then your bank's going to be upset with you, and you're going to end up in business rescue. It's a tale as old as time. You know, you can't throw money at a problem; it just doesn't make the problem go away. And I think a lot of that is happening right now, and the bank workout departments are very reticent to advance. And given the kinds of points that Gideon made earlier about success rates, people are quite skeptical, and it's a very different phenomenon. I think guys have suddenly found themselves in distress. They've always run their businesses quite successfully, and now they're saying, well, we can trade out ourselves. We don't need support and assertion. So I think there's those three things going on. Money around, the banks are keeping the workout departments, and the management themselves think that they can work it out. But time will tell whether they can or can't.
Thank you very much, Robin. In the interest of time and wrapping up, maybe if I can, and I'm glad that we've got a junior, an experienced, and a senior sort of business rescue practitioner on here. So are there any sort of questions that or concerns that Gideon and Charles would want to raise with George and Robin, who, as pointed out earlier, have done a lot to contribute to the business rescue industry? Sort of some words of advice or some pointers. And if there's anything that George and Robin want to raise with Gideon and Charles, is there any sort of advice or pointers that you can give out? Please go ahead.
Thanks, Jonathan. I would say, you know, coming from a junior point of view, I've been in this field going to conclude my second year, and I believe it's of utmost importance to gain the skill and experience of the seniors. You know, and there's a significant amount of juniors that is accredited by the CIPC that start off in the business rescue field. And, you know, how do you start off responsibly? I should have asked that question to myself when I started, and my answer was to engage or to start with, or actually I really started learning when I engaged with the senior practitioners. So that is what I can say. Advice to my peers.
Charles, do you have anything to add?
No, not at the moment. Thank you.
Much. Robin and Gideon, Robin and George, over to you. I think George has just dropped or left us at the moment, or if he's still around. Robin and George, please carry on.
Jonathan, yeah, I think that it's not going to be easy, but I do think the continuing education requirements, whether it's psych or whether it's SARIPA, whether it's the TMA, those programs really need to be reignited to start dealing with some of the skills deficit. There are programs out there. I mean, you know, it's the last closing day for the MPhil from UP today, if you want to do business rescue and turnaround studies. You know, I don't know what the response rate's been to that. But I think that the COVID issue has just got people battle fatigued right now, and we'll see the corpses and the bodies washing up on the shore in the next couple of months.
George?
From my side, I think continuous education is the key. As a business rescue practitioner in practice, I think it's a duty to talk to every business rescue practitioner that phoned you, ask you for advice. I started a mentorship course It fell behind a bit because of COVID. But I think we must have a forum like this. This is a fantastic forum, and we have to actually on a weekly basis go ahead and ask questions and answers. Just what I tell the people that I try to advise is common sense. This is a common sense a field. Don't be too clever. Just use your common sense. It's a plus and a minus, and at the end of the day, it must be a plus. Otherwise, you don't have a business.
Awesome. Thank you very much, guys. I'd like to take this opportunity to thank our panelists and all who have logged into the roundtable. We are planning to hold another roundtable in October, which will be looking at the legal aspects of business rescue. A copy of this roundtable will be made available on turnaroundtalk.co.za soon. Until then, thank you very much for your participation, and let's continue with the success in the industry.